A jury of your peers. Most people think that phrase is in the Constitution. It's not. And the gap between what people assume the law guarantees and what it actually guarantees is exactly what played out in the Karmelo Anthony jury selection, using a legal fix with a far stranger history than most people realize. Hi, I'm Melba Pearson, also known as the Resident Legal Diva. Be sure to like, comment, and subscribe to my channel and to my Substack, where I give breakdowns on different issues impacting everyday life vis-a-vis of the law. So, I'm going to talk to you about the Batson case. But before I do that, let me tell you about the history that led us to that. So, before Batson, the standard in jury selection was called Swain versus Alabama. Now, this is a 1965 Supreme Court case that made race discrimination in jury strikes nearly impossible to prove. So under Swain, defendant had to show a pattern of systemic inclusion across many cases over time, not just what happened in their own trial. That standard was, by design, basically unmeetable, right? But then came James Kirkland Batson. He's a black man on trial in Kentucky for second-degree burglary and receiving stolen goods. During jury selection, the prosecutor used his preemptory strikes to remove all 4 black people from the jury pool, leaving an all-white jury. Batson's attorney was like, hold up, nope, ejected on the spot, saying that it violated Batson's 6th and 14th Amendment rights. The trial judge denied the objection and never even bothered to ask the prosecutor to explain why he struck the 4 black folks. And to no one's surprise, Batson was convicted. This case ended up reaching the U.S. Supreme Court, and in 1986, in a 7-2 decision written by Justice Lewis Powell, the court ruled in Batson's favor and threw out the old Swain standard. And then the court ended up creating a 3-step test still used today. The defendant raises an objection, and the prosecutor must give a race-neutral reason for the strike, and then the judge decides if it's legit or not, right? What was interesting was the amazing Justice Thurgood Marshall agreed with the ruling, but he went even further. He said that the ruling didn't go far enough, and that the only real fix was eliminating preemptory strikes altogether because he predicted, rightfully so, that lawyers would always be able to invent a race-neutral sounding excuse. And 2 of the other justices, Chief Justice Berger and Justice Rehnquist, they dissented, they disagreed, warning the decision would undermine a trial tool with centuries of history behind it. So, here's the detail almost nobody ever talks about. Batson himself was serving a 20-year sentence when the Supreme Court ended up ruling in his favor. Rather than rolling the dice for a retrial, he just pled guilty to a lesser charge and got 5 years. So even the prosecutor who struck those original jurors later, later on said, the ruling was a good one. The case's own namesake ended up having a very complicated history afterwards, right? So Batson challenges usually involve it's basically a footnote for a doctrine that just spent 40 years struggling to live up to its own promise. So now that I've given y'all the history, let's bring it to real time. So jury selection in the Karmelo Anthony case started in June of 2026 with about 500 prospective jurors called to the Collin County Courthouse. The pool got narrowed through the rounds of questioning as normal and strikes, and it got down to 12 jurors and 6 alternates. During the second round of strikes, prosecutors used their peremptory challenges to remove 3 black prospective jurors from the panel. Now, backing up for a second, people might be like, what is peremptory challenge? A peremptory challenge is basically the ability for either side, because both the prosecution and the defense get these challenges, right? And you get a set amount. And so you can use it to dismiss somebody who you don't think is going to be good for your side. You shouldn't just be dismissing them based on race. It should be, oh, they weren't giving eye contact. Separate issue. But I'm going to get into some of the excuses used. Some of them can be sus, but some of them can be legit, right? Because you can tell if you, having tried tons of murder cases, right? Former prosecutor, did this for 16 years. Trials are my jam, right? You get up in front of the jury, you're talking, whatever. You can tell when someone's not vibing with you. You can tell. Like, to be good at this, you got to be pretty decent at reading people and reading body language. And you can already tell if somebody's giving you the eyeball, like, or, they're looking at the defendant in a particular type of way. Whether you're a prosecutor, you can tell that they're looking sympathetically, or if you're the defense, you can see that they're shooting daggers through their eyes at them. You're going to try to figure out a way to get that person off. And so you can point to an answer that they gave during questioning that you're like, yeah, that didn't sound right. Or you can point to, they were falling asleep. Well, obviously, if you're falling asleep during jury selection, I know there's good reasons. You could have been working a night shift, whatever. But the question still remains, are you going to fall asleep during trial? And if you do, that could mean you missed something important and then a miscarriage of justice occurs, right? So there's legit ways that you can strike somebody off of a jury that has nothing nefarious in mind, okay? So there's that. Now, going back to Karmelo Anthony, the minute those 3 black prospective jurors were struck, the defense immediately objected. They were like, nope. And what did they say? Batson challenge. Need a race-neutral reason as to why these 3 people are being eliminated. The prosecutors offered a race-neutral explanation, which was all 3 were educators. And their argument was that this made them too close to the subject matter of the case. The defense obviously was like, no, because there's a white educator who's also in the same pool and hasn't been struck. Judge John Roach overruled the Batson challenge and allowed the strikes to stand. So the seated jury, 12 people, 0 black jurors. And I will say, right, that explanation was hella sus to me. Because it's kind of obvious. If you got one teacher here that's white, and you got 3 other teachers over here that are black, you keep the white one, but you don't strike the black ones. It's kind of obvious why you struck who you struck, right? Now, would that have changed the outcome of the trial? We'll never know. But that's the thing, right? That's why addressing these jury selection issues are so important, because you never know how that can impact someone's life and liberty, right? Now, if the defense had struck the white educator, I'd have less to say, right? Because now you have a whole category of people that you struck. So, anyway, now, getting into the legal aspect of this. So, first off, let me dispel one myth for you, right? So, a lot of folks think the Sixth Amendment guarantees an impartial jury drawn from a fair cross-section of the community. It does not guarantee that the 12 people who end up in the box will match the defendant's race or the community's demographics. Yeah, a jury of your peers is a phrase from English common law tradition, not a constitutional requirement about the final jury's makeup. So what Batson actually protects is narrower and much more procedural. No party can strike a juror because of their race. And that's the same exact 3-step test from 1986. You gotta show a race neutral, you gotta have the issue, they gotta have the race neutral reason, and then the judge makes a call on the credibility of the reason. This is where Batson runs into its most well-known weakness, because almost any reason can get you past step 2. They're an educator, they seemed hesitant, they didn't make eye contact. The real test is step 3. And it turns on basically comparative evidence, right? If the state's stated reason applies just as easily to a juror of a different race who wasn't struck, the courts have held that's strong evidence the reason was pretextual. And that's precisely the argument the defense made here, that the white educator was treated differently than the 3 black educators given the identical rationale. And the judge was like, nah, they cool. and found the state's explanation credible anyway. So this is the surprising part of all of this. Batson is a real legal fix, and used exactly the way that Justice Marshall predicted lawyers would learn to round around it. Deferential appellate review of a trial judge's credibility finding is one of the most consistent criticisms of the Batson doctrine nationally. And it's not just a Texas problem. 40 years after the ruling, courts around the country are still trying to figure out and deal with the same failure mode. And this year, on the exact 40th anniversary of the Batson decision, a Texas man named James Broadnax was executed after his own Batson claim that prosecutors struck every black juror at his trial was rejected on appeal. So here's the bottom line. Karmelo Anthony was convicted of murder after about 3 hours of deliberation, and he was sentenced to 35 years. His new legal team, which includes the Texas NAACP president, Gary Bledsoe, and attorney Russell Wilson, too, has filed a notice of appeal. And the jury selection record, including the Batson ruling, is expected to be the center of this. Now, whether or not the argument succeeds is a different question than whether it was the right one to raise. I don't know. 40 years of Batson history. I don't know if the odds are in their favor, but you got to work with what you got, right? You can't invent what isn't there. So there you have it. Sound off in the comments. What do you think the fix to Batson should be? You think Justice Marshall was right? Now what? I'm Melba Pearson, also known as the Resident Legal Diva. Stay safe, stay informed, and keep demanding justice. Take care.